So first thing is, go ahead and tell us about yourself, Suzanne.
So I'm an attorney with IE Law Group, which is a video game exclusive law firm that's based in California, but I'm near Chicago. Another of our attorneys is based in Kentucky, so we're all over. We also have clients in a lot of countries, literally all over the world. So we cover all different kinds of law. Primarily, we do transactional law, so that means things like your contracts and your negotiations. We also do intellectual property, which includes copyright and trademarks. I've just recently been certified as an expert in privacy law. So I handle all of the data that you shouldn't be collecting and tell you that you shouldn't be collecting it, and then you don't listen to me. Um, but that's okay. That's just how most of my advice with clients goes. They call me up and they're like, "Hey, I have this question," and then it's followed up with, "But I wanna."
Is
Um,
it does it have a lot to do with that specifically? Like, does that have a lot to do with like collecting like gameplay information for like testing purposes?
it depends whether or not you're collecting information about who the player is. So if you're collecting things like their ISP, you should probably be concerned, or any other IP addresses, even as down to like city location, demographic information about their age based on like their player profile, if that's required at sign in. Any kind of demographic information is going to get you in trouble. Geolocation information, then obviously if you're recording voice or video, you should just stop right now. Like, that's not even advice, that's just a statement of fact.
Well, I mean that was a little out of order, but I was just kind of curious.
Yeah, by
But
all means. There's no
probably
order here.
the probably the first thing that a lot of people have questions about is copyright. So what is copyright?
So copyright is the thing that covers your expression of an idea. You can't copyright an idea. I can't copyright zombie game, as lucrative as it would be, but I can copyright the way I draw zombies in my zombie game, the code I use to program the zombies in my zombie game, and all of those little intricate things that are the way I express it. Now, the issue with that is there's something called scenes of fare, which are the types of things that are necessary in and common for an expression of a thing. For example, I can't copyright gray hair on an old woman because old women tend to have gray hair, and it's just part of the situation. Um, so even though I express my old woman with gray hair, there can be plenty other gray haired old women.
So what should they copyright then, outside of like general ideas?
So this is all a question of money, which is honestly going to be what this entire presentation is for most of you. The audience is a lot of indie developers and folks who are solo working on their first game. Copyright is honestly one of the cheapest options for you to protect your game, so you can copyright everything. Copyright allows you to protect your code, but it only protects you from almost exact or exact copies of your code. So if someone literally went in and wholesale stole your code, copyright would be good there. Copyright's a lot more useful in images and sounds. So the Copyright Office is now generous enough that with one submission, you can just mail in your game and everything included in that game, like your character designs, your music, your sound effects, the plot, can all be included in your copyright with just that one submission.
Oh, good. So sometimes people, when they're developing, use assets from other games, to fill in while they're building it. So how long can they use those before they have to worry about that?
So this is one of my favorite things about my law firm is that we understand the difference between the legal question and the business question. So the legal question here is, is it copyright infringement to use someone else's assets while building your game? And the answer is yes. You are breaking the law when you do that. But if you're doing it in your house and showing your buddies, as long as your buddies aren't terrible human beings, you probably aren't going to get reported to whomever you borrowed the assets from. So it becomes much less of a concern if you're just hanging out with your friends working on it. It's, the wider the distribution, the more likely you are to get caught, and getting caught is where you start having those legal problems, even though it's been illegal from the start.
Um, so if they found a free asset bundle, should they worry about that?
Yeah, so free asset bundles are the bane of lawyers' existence, and sometimes you'll see us on Twitter just like rallying against them. The issue is that you don't know where those assets came from, and unless you're able to get some kind of contract where the creator's like, yeah, no, they're totally mine, and I will pay all of your legal costs and indemnify you if you get sued because of copyright infringement, you're going to have some serious issues when you find out that that's actually all of the assets from this game in Asia that has a really great legal team that have just been ripped off and put online for free as like a side project.
What about music? Like, if someone wants to sample music, how much of the song can they use?
So the lawsuits have actually gone down to just a couple beats. Um, the rule of thumb is enough to be recognizable. So really, you should definitely hire musicians and pay them if it's at all possible, or make your own music. I believe you guys have some great musicians coming through to talk about game music. Yeah, did I see
Uh,
that correctly?
on Sunday we have a guy. Yeah.
Yeah. So like, talk to folks who actually know what they're doing and try not to just steal the backbeat from a popular song, because if it's recognizable, you're going to get found out if your game reaches any level of success. And I mean, that also is a question of, if it's a game, this is the business question again, if it's a game for you and your buddies that no one else is ever going to see. I have a game that I made, I think all of 10 humans have seen it. I could probably put a really popular song as the background music just because no one's ever going to do anything about it. It doesn't make it legal or okay or good, but it's the level of risk you're willing to tolerate.
And big part of copyright now, especially with YouTube and everything like that, is DMCA takedowns. So if someone gets one, why would they get one, or if they need to send one, how would they do that?
So actually, DMCA takedowns are a huge amount of the work I do. We have some big company clients, like AAA clients, and I am their DMCA person, so I send these letters all the time. Um, it's pretty straightforward if you're doing it on a small scale. The trouble is when it starts getting on a big scale. Most websites that are based in the US, like YouTube, have a form online that you can access, and you just fill in the details. And if they have questions, like if you filled in something incorrectly, they'll just email you and say, hey, you didn't add this statement saying that you weren't trying to commit perjury when you made your initial claim. And then you can do that and they'll help you out. There's also, if you can find who the hosting information is, you can send a letter directly. Internationally, though, DMCA only applies to the US. So if you want to send an international takedown, the EU does have a process for the same kind of thing, but that involves a lot more of finding the host and sending out the letter, since they usually don't make those forms readily available for like US style DMCA takedowns. The hardest venue to get stuff taken down is Asia. If your stuff is being cloned, or if DevKit is available in China, you can send lots of letters and you can pay lawyers to send lots of letters, but the outcome is usually not great.
They don't really care.
No, they don't. They don't at all.
question going back to the assets. Halle Gaborin in the chat said, presumably assets that are purchased or acquired through something like Unity Asset Store, there would be no reason to be concerned, correct?
So Unity is not required to check every single asset that's listed in the store whether or not it's infringing a copyright. Unity actually has a process for flagging an asset pack as copyright infringing. So you may buy an asset pack through the Unity store and find out that it's copyright infringing. And well, you may not be on the bad end of a lawsuit because of that. It's quite possible that you could get a letter that would require you to switch out all of your assets after you've already built the game around those assets, after either a takedown through the Unity store or just the original creator seeing your game in the wild. So they're not necessarily safer. They're just, you're less likely to be wholesale sued over them. I'm just the bearer of bad news. I'm sorry.
So something that people get confused with copyright a lot is trademarks.
Yes.
What is a trademark and how is it different from copyright?
You cannot trademark your copyrights unless you're like Bethesda, who recently trademarked Nuka-Cola, even though it's an item within a game. But the trick for copyright is that it has to be something to signify your brand in commerce. It can be something like the name of your company, the name of your game. It can be your logo. It can also be specific colors, like Tiffany blue and John Deere green are both technically trademarks.
Purple.
Yeah. Similarly, there's certain companies that have trademarked smells.
Weird.
Yeah, so if you smell that in commerce, then you know it's that brand, which is an odd thing. Please don't trademark smells. I don't want that to
I
be
wonder.
like,
I wonder if Subway trademarked any of their smells because it's that bread smell or the cookies.
yeah, I wouldn't be surprised, honestly, like, because that's all chemical. That's not actually anything cooking.
Yeah.
That's just like a spray they get in a jar to the Subway, and then it's horrifying.
Yeah.
Yes.
So should they worry about trademarks before making money, um, or if they're not planning on making money?
So, like, copyright is the entry level of IP protection. It's a really simple form online. It's relatively cheap. It holds on for as long as you're going to be around and for as long as your game is going to be making money. Trademark is like the next step up. The form is a little bit more complicated. It's going to cost you more money. At least, I think the cheapest option is 275 right now, but it goes up to closer to 400 depending on what you need in your trademark. It's really great if you're looking, if your title's super creative and you super need to protect it and you're worried that other people are going to steal it. I'd always recommend having a trademark just from a protective standpoint, but it's not the first thing you should be spending your money on. Definitely a little bit more complicated, so something you're going to consider looping a lawyer in on. You can do it yourself, but then you're going to get angry letters from the trademark office, and as friendly and helpful as they can be, it's never fun to get an angry legal letter.
Is there, if they do want to file for a trademark, is there like a process to get that started? Like, how do they do that?
So ideally, you're going to contact a lawyer, but poor indie audience, right? So the trademark office website actually has an online form, and it's several pages, and you go through and you answer different questions, like about the name of who owns the trademark. So whether you as an individual or a corporate entity, you answer questions about your corporate entity or you as an individual. Then you upload an example or type out what your mark is. So the name of your company or your logo or the color that you're claiming. That's where you make certain statements about your logo. And then you put it in a class. So classes of trademarks are what you're using it for. So food products are a different class than video games. And when you file for a trademark, you're saying, I'm going to use it for this specific type of commerce. And that's where folks can get really mixed up and confused, in addition to things like saying that they aren't going to use the word games except in the trademark as a whole, and they're not trying to trademark the word candy wholesale or anything, like a jerk would do. Um, But yeah, so the most interesting thing to me about the trademark application is entirely useless legally, is that it saves in a .obj form. And I don't know why. Like, they don't save it as a PDF or a doc or any other way that you can edit your information offline. It's just a .obj, and if you change the file name at all, they won't allow you to upload it again. So interesting side note, don't change the file name when you're trying to save a trademark application.
That's odd. So if someone has a really good name for their game, but someone already trademarked it in like a different form of media or something like a band or a movie title, what should they do?
So this is going to depend on a lot of factors. One, is there any reason why a consumer would ever be confused with something like a band or a movie title? They're both entertainment products, and so is your game. So you have a little bit more risk of confusion there. If your game name is the same as the name of a loaf of bread, there's a little bit less risk of confusion. So the trademark examiner may flag it as a concern, but then you just say, listen, games aren't bread, in much fancier language. And then the trademark examiner will probably be like, okay, I understand there's no risk of confusion here.
So actually, quick question. This is probably a very specific instance, but on the bread example, if say I Am Bread, the game, decided to call themselves Wholesome or something like that, for whatever reason, would that then kind of...
Is Wholesome a brand of bread?
Yes.
Okay. I don't know my bread brands that well.
Yeah,
that would be problematic. I'm sorry. I love carbs too, so this is kind of embarrassing. So that might be more problematic, because there you can see where a consumer would be like, oh, this is a game about bread that's being sponsored by this bread company. Really, courts assume that consumers are kind of dumb. As a general rule, there are a couple of rulings where they're like, wow, these people are really smart and can figure this out. But as a general rule, when courts look at things, they assume people are going to make all of the mistakes possible. And the copyright examiner is going to err on that same side of caution. So you're looking at something there where, like, yeah, you're probably going to want to reach out to Wholesome. And that's your other option. If you just don't want to deal with you making, or your lawyer making, that, like, fine scale determination about whether or not there's actually going to be confusion, you can just email them and be like, hey, listen, I want to use this for this. Can I get a license? Or will you write a letter saying that it'll be okay and that there won't be any confusion? Or however you want to phrase that conversation so that you can both move forward in your respective brands without stepping on each other's toes.
So if someone's already registered the game name, their game name, but someone else is using it for the game, but they don't want to, have conflict, is it okay if they just let it go?
No, it's not. Trademarks have to be enforced to be held. If your trademark becomes generic or overused in other games, it's you're going to lose your registration and no longer have that protection against real issues in the future. If you're a big enough company, or if you have enough money, it's less of an issue. Like Google has recently been fighting a genericizing battle against the trademark office because people say just Google it, and using your trademark as a noun or a verb or anything like that actually invalidates the trademark. So saying bring me a Kleenex as a generic word for tissue actually works towards invalidating Kleenex's trademark on the Kleenex brand. Same with Band-Aid. Xerox was fighting a battle for a while over whether or not Xeroxing would genericize their trademark. So trademarks are something that need a lot of attention and time.
That's kind of interesting because there could be a little bit of like if a bigger company wants to invalidate another company's brand, they could run like a campaign to like genericize their brand almost, I would think.
It seems really, really evil, but they totally could. If you have a major competitor that just happens to fall into the common use for something, but then companies can do really evil stuff. I'm not sure if you guys are aware, but there are some evil companies out there that maybe slow down your bandwidth on a day that you're trying to do a presentation online, but whatever.
FCC.
Comcast.
For the win. So moving on to a different topic. Let me actually just double check there's no questions there. So Hale was I asked a question. I don't know if this was covered yet or not. So then, could I make a soda called Nuka-Cola because it's the beverage industry and not the game industry? Is the question. Which I think there is actually. I think they did make a drink called Nuka-Cola, but
almost certainly not. Bethesda has beaten you to that punch. The reason why they wound up trademarking the Nuka-Cola brand name is because of all of the fan art that was out there circling around, and they wanted to have another venue with which to enforce their rights to be the only one that distributed Nuka-Cola products. So if I remember correctly, and I haven't checked that filing in a while, they filed in a bunch of different classes. So you're definitely not going to get away with that. It's just like Coca-Cola has filings in a bunch of classes, and they also have enough name recognition that even though Coca-Cola is a beverage and your game is a game, if you called your game Coca-Cola, Coca-Cola could totally shut down your game.
Okay, so moving on to a different topic, IP defenses. What is fair use and what is parody? What's the difference?
So fair use is the thing that everyone yells whenever someone takes down a Let's Play. It's basically the claim that you have a reason listed in the statute, because there's only so many statutory fair use defenses, and they're things like for criticism, which is theoretically what Let's Plays would fall under, but we're not really sure whether or not that's true since there's never been a case clarifying it. Parody is a subset of fair use almost, but it specifies that you have to be making fun of the thing you're talking about. So you can't use the thing to make fun of something else. That's satire. You have to actually make fun of the thing itself. And I'm trying to think of a clever example, but my brain is still all internet problems. So I really don't have one off the top of my head. But for example, if you were parodying Coca-Cola and you made a drink that tasted awful and then you used that drink to talk about, I don't know, chemical infusions in Pepsi or something, that wouldn't be a parody since you're not talking only about Coca-Cola. You're talking about Pepsi too. So you have to really narrowly focus for a parody.
Okay. Um, so, what should someone do if they get a cease and desist? Should they just send a letter back that says fair use?
I'm pretty sure that has literally never worked. YouTube has become a lot better about hearing out your defenses and making fine line determinations about whether or not your situation is fair use. And there are a couple other websites and hosts that will, when you respond to the claims, I think GitHub is one of them, where when someone tries to DMCA your repository, if you send back a letter saying, listen, this is why it's okay, GitHub, I believe, is one of the companies that will hear you out and try and help you out there. But sending a letter back to the company itself saying, but wait, fair use, no one at that company will care. I mean, they might care in like the, oh, this is cute kind of way, but fair use is an affirmative defense, so it can only technically be raised once you're in court. And after you've admitted, yeah, I totally stole their stuff, but it's fine because fair use. So it's not necessarily something you want to put out there in the world that'd be like, yeah, I totally stole your stuff, but it's cool because fair use.
So what about like fan games and fan art? Would people get in trouble for that? And actually, some of the more relevant stuff right now would be like mods.
Yeah,
People have
those
been
are
getting taken down.
all illegal, all just so illegal. And the small edge cases where, oh, there's this dude who did a mod for Skyrim that then got offered a full-time job and they love it, or oh, the company is now paying this modding team to make their mod a full-scale game, isn't evidence that modding is any more legal than totally illegal, because you're working off of someone else's product. So basically you're creating what's referred to as a derivative work, and the original copyright owner has ownership of not only their content within your derivative work, but also the derivative work itself.
Um, okay, so one thing that, again, changing topics, but one thing that a lot of indie devs really have to worry about, or should worry about at least, if they're working if
Please.
they're working with other people, is contracts. So when should they use contracts in that situation?
Literally always. But that's just my like wishful thinking, perfect universe response, right? Like, clearly you're not going to have everyone sign contracts about everything all the time, because then you wouldn't actually get your game made or your programming done or your art assets bought or whatever else you're trying to accomplish. As often as possible, on any deal that you feel is valuable enough to justify it. So anytime someone's adding a large or anything to your game, anytime you're forming a business with someone or you're talking about splitting profits, money is always a really good indicator that, hey, this should be in writing. And the thing is that courts have recognized things like email chains between you and other parties as a contract. So if you've been emailing back and forth with someone and all of a sudden you get into a dispute, those emails could have formed the basis for a contract where you said you would split revenue 50-50, but then offline you said 30-70. The emails would be what the court would look at as evidence of how that was going to shake out. There's also a couple contract tools online, and while I wouldn't wholeheartedly recommend them because they're often full of holes and not the strongest things in the world, something is better than nothing in most cases. So Do Contract, which is contract and then the parentheses, is a tool that's available online. It's a fill-in-the-blank contractor contract, if I remember correctly, that lots of folks go to because it's entirely free, it's plain language, it's written with international concerns in mind, and while it's not as strong or good as a lawyer-tailored contract, it's something that'll give them that basic level of protection.
What about a partnership agreement? What is that exactly?
So if you are working with someone else, you've de facto formed a partnership, which means you're both responsible for all the things. If you form a legal entity of a partnership, that's a different thing. That's closer to forming an LLC or a corporation. You have to file some documents depending on your jurisdiction. But the thing to be concerned about is how that's going to shake out in the end. Because the stuff no one wants to talk about is what happens if you break up with your best friend, what happens if your girlfriend steals art assets, who's responsible for that legal bill that's going to happen because you're getting sued, things of that nature. So partnership agreements are the things that outline your relationship and how that relationship is going to end. What you get paid when things go well, how often you're going to get paid. If there's an ownership split or if the assets are owned by different entities, that's an important consideration to put into a partnership agreement. You just want to throw in everything you can into that doc. And I mean, worst case scenario, open a Google Doc today and just write down everything you can about how the relationship between you two works and should work, so that if something happens, you can refer back to it and save copies offline so that they can't edit it when something happens, so that they get 100% of everything.
What if someone needs to file an NDA with someone or confidentiality agreement? What's in those kinds of contracts?
So I actually saw a hilarious one recently, and I can't tell you who because these are client confidentiality issues, but it's a major developer, and then a smaller developer was going to do some work on a game that they're coming out with soon. And within their NDA, they require that if you got any portion of their game for like review or playthrough, you had to store it at your home office using top of the line security measures, covered entirely by insurance for the value of the game and the value of all of the assets and inventory related to the game. So like millions of dollars of insurance, like just the list of things that they required for you to even have their game in your possession as a contractor with them under an NDA, which is supposed to be just the, hey, we're just chatting things out type conversation, was nuts, man. So NDAs seem like these really low-key, just sign it, it's a page, what could possibly be in their kind of documents. But really, they create the basis for your conversations with the other party. So things you want to look out for are super shady things like that. And also things like whether or not the conversation is covered mutually. So if you disclose your really great game idea to this company, is it covered by the NDA, or is only what they tell you covered? So really looking at that document, which is shocking, it's like telling people to look at the terms of service, is super important. In the case of the NDA I was talking about, our client actually wasn't going to be looking at that game code, so it didn't apply and we let it slide, but it was still that it could be buried in literally a 2-page document and require you to do such high-level things was impressive.
So we have a few minutes left. Are there any other questions on here that you like really feel like are important, or should I just continue on?
I mean, I always love talking about privacy because
Sure.
obviously, but so I can jump in there and just give you a quick rundown of things you should worry about.
Sure.
Okay, so first of all, when you're collecting email addresses for marketing purposes, I believe most people at this point use MailChimp and Constant Contact, right? Like that's the standard in the industry. But if you're just using a spreadsheet and sending out emails, make sure you're giving people the ability to unsubscribe. Make sure that the email addresses you're getting are actually subscribed, so send them an email saying, hey, you've been subscribed to this list because. Make sure that you are saying who you are and why you're sending the email. Just be really upfront and straightforward about what's going on there. There's actually, let me see if I can find it.
Just send some shady links.
Yeah, just, if you could bounce it around some servers so it's unclear where it's coming from, that's probably best, honestly. Like,
sarcastically
obvious.
Put that.
Yeah, please don't bounce around emails and send shady links. You can't see me smiling, but I am laughing about that. Also, just because you're using something like MailChimp or Constant Contact does not mean that you're protected from any kinds of issues that there may be with the compliance with what's called the CAN Spam Act. You have to be the one to monitor to make sure that those emails that are going out that are advertising your game are compliant.
And like what I do is we have like a place to sign up for a newsletter, but I manually have set up an an address book for IRX 17, for instance, and send out people who we've been in contact with or have signed up for the thing, and I tell them if you want to unsubscribe, reply to me.
Yeah.
I do tell them who I am and that sort of thing. So, just putting that out there as an example. It's not hard. It adds like a little bit more time and effort, but it's not hard.
Yeah, the requirement is that you respond to unsubscribe requests within a reasonable amount of time. So there's a little bit of leeway there. You don't have to do it immediately. I've seen giant companies claim they need as much as 5 days to remove my data from their systems. So if you as single individuals sending out mailing emails need a day or two to remove that email, you're not going to get like swooped upon by government agents that are going to shut down your company. As awesome as that would be. The other thing that I really want to bring up privacy side-wise is COPPA, the Children's Online Privacy Protection Act, which applies to persons under the age of 18. I know a lot of games are made for children, and a lot of games are made in cartoon styles that might appeal to children. They have a really broad application of what is targeted to children. So like the Family Guy game got flagged because it's made in an animated style as applying to children. So data they were collecting on their players got flagged as data being possibly collected on minors. And that's a really big concern because they can make your life hell if they want to. Some of the cash penalties are like $250,000, $300,000, and that's not even only the developers that are collecting that data. It's also folks that are like, if you have an ad server through your game and that ad server is collecting player data, you are responsible for the actions of that ad server as far as the FTC is concerned.
So one more question before we stop, because we have something in the chat. It says, yes. I would like to know what the risks are of people wrongfully filing a copyright claim against you. We all know the enormous issues with patents that stifle innovation in the software industry and sometimes destroy companies because of patent trolls. Copyrights are not patents, of course, but is there a risk of people doing something similar to game developers based on their perceived copyright over a plot or something silly?
So, I mean, it's a DMCA issue, and the DMCA allows for, I believe they call it perjury. It's essentially perjury. It's lying on a claim of a legal right. So what you're looking at if you file false DMCA claims is all kinds of fines and issues with the state. So it's not even something the developer has to pursue in terms of a false copyright claim. They can point out that the copyright claim is false, and then report it to the state's attorney, who will handle it in terms of legal outcomes.
Awesome. I will say that check out IE Law. Suzanne Decu is part of that company, so check them out if you would like not legal advice unless you're paying for it, but she could probably answer like these general questions if you had some.
Yeah.
Suzanne would, I'm sure, let you know if it's like going too far or something, but.
Yeah, I draw that line. And please note that, like, well, my law firm is obviously the best law firm in the entire world. Ha ha ha. Not, I think it's true, but not objectively true. There are lots of video game lawyers out there, and we may not be the right fit for you, but we could be. So feel free to reach out to a bunch of folks and have coffee with them. Choosing a lawyer for something like your game company is kind of like dating. You want someone that you can call up and be like, hey, I have this concern that's kind of vague. Is it something I should be paying you for? And you want a lawyer that'll come back and say, hey, that vague concern is fine. Just move on with your life. We'll deal with it if it becomes an issue. Or someone that'll come back and say, hey, we really need to deal with this now because it's super concerning. Most lawyers will give you a free consultation up front to make sure that like your legal expectations align with what they do. I am project manager with the Video Game Bar Association. I represent 500 attorneys all over the world who work exclusively or primarily in games. So there is someone out there that can help you in your budget with what you need in a way that you find enjoyable.
And follow Suzanne on Twitter if you'd like, at ZTheGamer. Do that as well.
Yeah, that's mostly dog pics, not gonna lie.
Legal dog pics.
Yes.
So thank you so much for doing that, Suzanne. It's always a pleasure.
Thank you for your patience. I'm sorry that...
no problem.
Yeah.
Hopefully next year you come again.
Absolutely.
Just for me pronouncing your last name correctly.
I mean,
And
it's a big selling point.
with that, I'm going to transition over to some music. Um, we'll still be around, but it's just kind of a buffer period before we go into our second game exhibit of IRX 17.